This week on Lewis on the Law, I have yet another great show for you. I have attorney Sasan Namat in the studio with me, and we're going to talk easements, trespass, and nuisance.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I am your host for the next 48 minutes. And it is my privilege to welcome back a friend of the show, attorney Sasan Namat. And we are going to we're going to have a little conversation today about easements, nuisance, and trespass. Sasan, how's it going today?
Oh, it's going wonderful. Much better now being here. Thanks for having me on the show again.
Yeah, definitely. So we're talking easements, and I know some of you guys might wonder why easements, but I think it's an extremely important area of the law, and a lot of people don't really kind of understand it.
That is correct, and it's one of those areas that I believe if you're a landowner, you most definitely touch easements, but it is, again, illegality, and a lot of folks perhaps just overlook it. But here we are, and we're going to have a good conversation on it. And you're both land use lawyers, and I know that you've done quite a number of these cases, and you do this extensively. So,
yeah. So for those of you guys, I specialized in easements for my first couple of years out of law school, and literally all I did were easement was, and people don't realize it, but there's a whole world of people who do nothing but easement work. They're called right-of-way workers, but there's right-of-way websites, the whole thing. It's crazy.
that's right. I mean, when you think about it, the utility lines, the right-of-ways, the airplanes in the sky, they're passing through someone else's land.
And
go ahead.
And it's all easements, basically. All these utility lines you see, everything, it's all about easements.
So James, what is an easement?
Okay, so thanks for asking that, Sasan. An easement is a non-possessory right in property. So you're a landowner and you have granted someone else some type of right of use or access in your property. And it's important to know that their right is a non-possessory right. It's not something that they don't possess the land. The property owner maintains the underlying interest in the land. Say something happens that destroys the easement, then it reverts to the property owner. So it's pretty important to understand that it's a non-possessory right to land, but it does give that person some rights to use land that's not theirs.
So what you're saying is that there are two folks, and they both have an interest in the land. One is the owner, the other one is for the right to use.
Yeah. So
for a certain purpose.
So the owner grants an easement. And an easement can also be a restriction for a person. You can actually have a restrictive easement that actually prevents a person from blocking your view of the ocean. And I think we can get a little bit into that when we talk about different types of easements, because there are several different types of easements. And I'm going to just kind of go through them real quickly, and then we'll get more in depth in them. And I think people might be confused because this show is actually called Easements, Trespass, and Nuisance. And people are like, well, why those three together? And it's like, if you have an easement or if you don't have an easement and you've got a case for damages and it becomes a civil litigation case, well, then what would be an easement case becomes a trespass or continuing nuisance case. So they're interrelated in the area of when it becomes a necessity for civil litigation to take place.
Correct. So in essence, the easement itself is the right of the property owners, and nuisance and trespass are those sort of when the breaches of those rights.
Yeah, that'll be your claim. If someone has dug up a hole on your land and put utility lines through it without you granting them an easement or without there being an easement that was already in place, then you have a case for trespass or nuisance. So that's why those three are interrelated, and that's why this show is called Easements, Trespass, and Nuisance, because there's a natural relationship between the three.
So, your listeners today, when they hear this, what they can learn is first the basic definitions of easement, and when they're created, how they're terminated, and what happens when those rights are breached, and the sort of cause of actions and the way to evaluate damages. Am I understanding that right?
That's exactly what we're going to do. We're going to talk about easement creation, easement destruction, and the types of damages that you can basically get from easements. So I'm going to really just quickly run through some of the main types of easements. We're talking about express easements, prescriptive easements, compulsive easements, easements by implication. Okay, so we're going to get in depth into prescriptive easements, but I'm going to touch right now a little bit on what an express easement is. And an express easement is basically when there's a contract, when you've agreed to terms and you've granted this person a certain right. And it may be to build a driveway across your land, or it may be to put AT&T boxes or T-Mobile boxes, Sprint. I won't say all the names. And it's basically a contract with them. And the thing to know about this contract, and this is why you need an attorney to actually negotiate this, because there's lots of ways in which you can structure this contract. You can structure this contract where it runs with the land, because an easement like this will actually run with the land for long periods of time if it's written that way. Or you can have an easement in gross where that is actually destroyed after a couple of years, or it can be destroyed when the property owner no longer owns the property, or when he dies and the property interest is transferred to someone else. And that's what they call an easement in gross.
So in essence, the express easement is when the grantor, person A, grants to person B for whatever reasons and for whatever benefits, and confers on that person certain benefit to use in of that easement.
and that's really what you want to see, and that's really, and even after we go through all these other types of easements, that's what you really want to work to. I mean, you want to work even if there is no easement, that you've got trespass, continuing nuisance. What you want to work towards is a solution where there is an express agreement, where the landowner, and this, I'm talking to you guys, landowners. If you have an issue like this, you need to go ahead and give me or Sasan a call and let us help you negotiate this easement, because you're going to get paid for that use of your land, and there is a dollar value that is attached to that, and we'll get into that a little bit later.
That is right. And here's the thing: the catch is to do it early on, before it's too late, because you want to make sure that easement is structured in such a way, not only contractually, but also on the way that it impacts your land and the rest of your land.
Yeah, and you definitely want to catch it early on, because we're going to get into prescriptive easement, and that's another ball game itself, when someone actually takes a right in your land, and that's a whole section in itself. I want to get a little bit into different types of easements though before we get into that, and something I want to touch on, which we're not really going to get that much into, is what's called an easement appurtenant, and that is when you have two parcels of land, and one is a dominant parcel of land, and that means the land has an easement that's structured into the land deal. And then you have a servient parcel. And just to give an example, you have two parcels of land and you need a driveway to connect the land. So you create what's called an easement appurtenant, and the servient land has a driveway across it that allows the larger land to be serviced.
Yes. So with the servient and the dominant, I know us attorneys doing land use, we would know that, but would you explain a little bit more what's the definition of that and how those two lands are defined this way?
Okay, yeah. So the dominant land, and they call it dominant and servient just because the dominant land is the parcel that the easement actually helps. Now the servient parcel is the parcel in which the easement is a burden to. And by burden, I mean that means it's actually a trail across your land. It may be your land, but someone else gets the right to walk across it, gets the right to maybe build a fence across it, or maybe gets the right to put a driveway across it. And so your land is servient to the dominant parcel.
So in simple terms, utility company comes in, the servient land is the landowner providing a certain benefit to the utility company, or so on and so forth. So
that would be a servient parcel. So we're almost at the end of this segment. Sasan, why don't you, and this is really important, and a lot of people don't even realize it. Almost everybody has got easements across their land, and you may not know it, but some of those easements may not actually be legal easements. People might have just built across, and trust me, I know. I used to work for the utilities. Utility companies sometimes will just build, and there'll be no agreement in place. And so you want an attorney to check this out for you, you can give me a call, James Lewis at 404-610-0075, or you can give Sasan a call. Can you give them some contact information for you?
This is Attorney Sasan Nemat of Nemat Law Firm. You can reach us at 770-285-8008. And we help land use professionals across the state of Georgia with not only easements in these sort of cases, but a lot of other cases relating to development.
You're listening to Lewis on the Law. When we get back, we're going to talk about easements by implication and prescriptive easements. You are listening to Lewis on the Law, and we've got a little groovy surf music going for you. It's a little no trespass, and I hope that gets you ready to fight for your rights. No trespassing on my property. And my name's James Lewis. I'm your host today. You're listening to Lewis on the Law. I want to let you guys know that each and every single episode of Lewis on the Law is now streaming online nationally. We are streaming on iTunes, Spotify, Google Play, you name it, and we're on it, and we've gone national. So make sure, and it's AI compatible. Just the other day, I said, Google, hi Google, play Lewis on the Law. And it played the most recent episode of Lewis on the Law. It was really cool that way. I'm like, wow, that is so neat. So we are AI compatible. We are national, and we're streaming. And if that doesn't serve you well, you can go to my website. All my old shows are archived on my website, jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can give me a call at 404-610-0075. I have attorney Sasan Nemat on with me, and we are both land attorneys. We both deal with real estate, property, land use. I know you get into a little construction and homeowners associations.
That's right.
Yeah. And I do a little probate stuff. You probably do some probate stuff too.
Not as much.
Yeah.
There's certain things I've learned to stay away from.
Yeah.
Kudos to those who do it. So,
yeah. I'm mired in probate litigation right now, but ooh boy, good times, fun. It's easy making a living, right?
Oh yeah, sure is. Especially when you're litigating. Fun times.
Fun times. I should have gone to school for digging ditches. And if you're digging ditches, you've probably got an easement or you're trespassing, and that's exactly what we're talking about.
That's
now,
right.
Sasan, I want to tell you a little story about why homeowners should listen to this show.
Tell us why, James.
And why they should take interest. So Imagine, if you will, those big gray boxes. You've seen them everywhere, right? You guys have all seen, driving down the street, you've seen the big gray
those
boxes.
Ones, huh?
Yeah, those big gray boxes. So I had a person in my neighborhood who was like, gosh darn it, I wish that big telecommunications company would do something about those big gray boxes. And he would come out there, they'd trench his yard, they'd dig up things, they'd throw stuff all over his yard. And he'd get out there and scream at them, and they would tell him, get back in your house before you go to jail. They literally did that. They said, you're about to go to jail, get back in your house.
Yeah, that happens.
And they'd continue trenching up his yard, driving tractors along his yard. And he finally got so fed up with it, he said, okay, I'm going to call the cops on you. He called the cops. The cops gave him a citation because big telecom company obviously has some rights, right? Well,
that's right.
Well, I was walking my dog one day, and he was like, "Can somebody help me?" He actually just said that, and I said, "Hey, I happen to specialize in easements," and we looked it up, and big telecom company did not have an easement written anywhere.
And how often is that, huh?
That is more often than you'd believe.
And
trust me, I worked for big telecom, and oftentimes when things got hairy and the pressure got high and the higher up said build, 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 you just go ahead and build and then say, hey, we are big telecom and we have rights and we're going here. And you guys are just going to take it. We're going to give you $10. And
if you're the homeowner who automatically assumes that these telecoms and whatnots can come on your land and do what they're supposed to do, then you most likely would just overlook it. But if you're listening to this show, now you're becoming aware of what rights you have and what you can do about those.
And if you got those big gray boxes on your property, you might want to give us a call and let me or Sasan check it out for you, because guess what? They have to pay you for that right. There is a dollar amount, and it can be substantial. Trust me, I've negotiated these before on both sides of the coin, for telecom and for the homeowners. And there's a dollar amount there for you. So if you got those big gray boxes on your property, go ahead and give us a call. My name is James Lewis, 404-610-0075. Sasan, how do they get in touch with you?
Sure. You can reach out to nematlawfirm.com, 770-285-8008. So, James, before we went to the break, you were talking about express easements. Let's talk about easements by implication, the ones that there's no express grants from the grantor to grantee, and it's just some sort of fuzzy situation of who knows what this promise was. So tell us more about those situations.
Okay, so that, and you kind of get into the area of prescriptive easements, but it's not really. It's an easement by implication. So when there's lots of parcels of land, a parcel of land has to there's a theory called the highest and best use of land. And Georgia's a highest and best use state. And it kind of guides that all land has to be usable. So when you have a landlocked parcel of land, and landlocked, I mean, you don't have access to the streets, you don't have access to utilities, you don't have access to bathrooms or sewage systems, then that parcel is landlocked. And so for the highest and best use of that land, you have a right to access the streets, the utility infrastructure, the city, the social goods, and when that happens, you have an easement by implication. But you can't just go ahead and say, okay, I have a landlocked property. I have an easement by implication. I'm going to build a driveway across your land. You can't just do that. What you have to do is you have to actually go in and you have to get a court. You have to go ahead and make your argument to the court saying, I have a landlocked parcel. It's not landlocked through a fault of my own. And I need access to the streets. I need to be able to get my car from the street to my house.
And you said a couple of really important things, James. One is no fault of your own, meaning you can't simply, if you have 100 acres of land, you can't simply sell out 80 of it and, get stuck with the 20 that is now landlocked due to your fault. So you can't do that. And then the other part that you mentioned, which was you have to go to court. When you do go to court, then tell us about that just compensation. You most likely will end up paying.
You'll have to pay for it.
That's right. So it's not going to come for free. So your land better be worth it for it to be developable, meaning, the dirt for it, quote unquote, the highest and best use for it to have some sort of value. So tell us how this implied easement goes hand in hand in some cases with the sort of prescriptive easement.
Okay, so that's really, really important. I do want to lay just a little bit more foundation for the implied easement. And Sasan brought up a very, very important point. If you have a 108-acre development or a 158-acre development, call us. We love you. Trust me, we'll help you with your problem. But you want to go ahead and negotiate these easements. Go ahead and negotiate easements that run with the land for a long period of time, preferably in perpetuity. And so you want to go ahead and call land use attorneys like us who are experienced at negotiating these easements and can help you go ahead and make sure that you don't have these landlocked parcels. But when you do, you get a court order, and of course you have to reach some sort of financial compensation and this becomes a easement appurtenant, where you have to reach some sort of compensation with the servient properties. And so and that's important, and it does kind of touch into prescriptive easements, because a prescriptive easement is like something that we call adverse possession as attorneys. And this basically is how you steal land. And people out there who don't believe in it, adverse possession is a real thing. There's criteria in which if you meet certain criteria, you own this piece of land. You didn't have to pay for it at all. You just had to occupy it for 20 years, improve it, be open and notorious. There's a multi-factor test, and it's called adverse possession. And you basically have taken someone's land, or have taken land. And some cities use this technique to redevelop blighted areas, because if the area is blighted, no one's taking care of the house, and some people want to come in and move into these areas and redevelop these properties, then it does the city good for that property be maintained, and the homeowners who allowed it, or the property owners who allowed that area to become blighted, they lose their interest in the property. Atlanta doesn't work that way. Atlanta, you have to have color of title or meet a longer statutory period. But for prescriptive easements, it's a little bit different. You don't actually own the land. What you do is you have an interest or a right to some sort of property right to someone else's land. So that other landowner still owns the underlying rights to the property, but you now have a right to walk across it, a path. And there's several tests, but I think we're running towards the end of this segment.
Yes. So we will get back to discuss this in more detail. I believe there's a lot of detail in both adverse possession as well as prescriptive easements. And it's one of those details that you definitely want to check with an attorney. At the end of the day, the laws are made to make sure utility of the land is at its highest and best. So meaning if you leave a piece of real estate abandoned for many, many years, and someone else makes a better use of it continuously with notice to everybody that's involved, then that party by law can argue for adverse possession and ownership of the premises. So it is, in essence, it's a matter of utility. And with that being said, I know we are reaching out towards the end of the show for this segment. You're listening to Lewis on the Law. This is Attorney Namad. We're having a really good conversation on easement, trespass, and nuisance. You can reach me at 770-285-8008. Again, 770-285-8008, or go to namatlawfirm.com. And my colleague James Lewis can be reached. Go ahead.
At 404-610-0075. You can always go to jameslewislegal.com or email me at james@jameslewislegal.com. If you even suspect you have easement, trespass, nuisance problems, you need to give us a call.
Welcome back to Lewis on the Law. This is Attorney Namat of Namat Law Firm, and we're here with Attorney James Lewis, and we're here to discuss easements, trespass, and nuisance.
Awesome. My favorite subject. You guys are going to think I'm a complete nerd, but I love talking about easements. And why? Because I spent several years doing nothing but going to jurisdictions and talking to them about easements.
That must have been a lot of fun.
It was a lot of fun, except for when they started throwing tomatoes at you. I didn't mind the apples and the carrots when they threw them at me, but once they hit me with a tomato, it splashes all over your suit, and
it messes up your suit.
Yeah, you got to get it dry cleaned and stuff like that, and every now and then, a couple of them threaten to get out their pitchforks and their torches. And
well, you don't mind the bruise. You just don't want to pay for the dry cleaner.
Exactly. I don't mind the bruising. Like a good apple, it just kind of hits you in the head and then leaves a little bruise. But a tomato, that sucker will splat all over you. And if you've ever done a community council meeting in the Northeast, you guys think I'm joking, but they're brutal. In the South, when we do zoning hearings in the South, everyone is so polite. People are like, excuse me, or even if they get upset, they're like, you bastards, you can't do this. In the Northeast, it can be brutal. They're like throwing things at you. They're calling you weasel. They're calling you snake and all kinds of things. It's horrible. I was shocked at the lack of civility that happens in those meetings in the North. I mean, here in the South, everyone's relatively nice. Even when they get upset, they're still kind of, well, thank you. I'd like to say my part, Mr. Chairman. Up there, they're like, Mr. Chairman, you're a weasel. You've sold out your communities. And they'll throw stuff at them.
Oh, yeah. And
Like, my God, really?
And, you and I, there we are as land use attorneys, sometimes representing the interests that you're being yelled at for.
Well, especially with me, since I came from big corporations, people were like, that is the devil himself right there. Even if I wasn't from AT&T and I was representing someone else, they just lumped me in with Verizon, AT&T, Sprint, T-Mobile, all of them. It didn't matter who they were angry at. I got it.
That's right. No, I mean, that's part of doing the job. But here we are discussing easements, and I know we touched on prescriptive easements a little bit. Mm-hmm. Why don't you tell us a little bit more as to how the width and keeping the easements and the different elements and requirements of establishing that easement by prescription plays out in reality?
Okay, so this is the danger about not challenging an easement initially, okay? Because like adverse possession, prescriptive easement is how a person actually gains a right to some, or they gain some right to your property. They don't own that piece of property like they would in adverse possession, but they gain some kind of right. And there are four elements that have to be satisfied before they can argue a prescriptive easement, or before a prescriptive easement is in place. And so the first one is there's always a time period. I know with adverse possession, there's a time period depending on whether you have color of title. That means whether you have some paper that says you have an interest in, or whether you're just occupying the property. The time period varies. But with a prescriptive easement, the time period, it doesn't matter if you have something that grants you a right and you think you have a right, or if you don't have a right at all and you're just taking it. The period is 7 years. So that's basically uninterrupted for 7 years. You've had this easement in place. And the second qualification is that the easement can be no more than 20 feet in width. So if it's 7 years and 20 feet in width, then you've started the pretty good groundworks to establish a prescriptive easement. Now, the part of this that really starts to is where a lot of litigation happens is whether the easement has been increased in size. That's your third criteria, is that you cannot increase the size of that easement in that 7-year period. And this is where people who are trying to establish a prescriptive easement often go wrong, because they'll spread it out. They'll keep spreading it out during the course. And so your 7-year period run is nullified. Say you've started off with a 10-foot path across someone else's land, and you're like, this is going to be my prescriptive easement. I'm turning this 10-foot path into a 10-foot driveway. But then you've turned it into a 12-foot driveway. Well, you've changed the width of that property, so you no longer have that 7-year period. So it's really important, and for the landowner, this is where you can knock out those big gray boxes, because trust me, those guys with those big gray boxes, even if they don't have an easement and they're saying we have a prescriptive easement on your property, I bet they've changed the width of that easement during the time. They've put another box. They started out with one box, then they put 2 or 3 boxes in, and then they put 4 or 5, and next thing you got a whole little row of gray boxes. Well, they've changed the width of their easement, and that's the way that attorneys like me or Sasan can come in, and we can attack that easement, destroy it, and basically make sure that those guys are paying you for that land, for that use of land, because that's what your utility infrastructure company, your telecom company, that's what they're going to say. They're going to say that we have a prescriptive easement, but then you'll bring out your pictures of how they've changed that easement over the years and how they've harassed you, and that's where we'll go ahead and destroy that prescriptive easement and force them into basically negotiating an express easement for you.
That's right. So in essence, the Georgia courts and the law wants to make sure that the prescriptive easement is for just what is necessary to get the job done, and it is continuous over a course of time. So when the property owner hasn't expressly chosen to give certain rights and non-possessory interests to a utility company or whatnot, they can't just go in and utilize the land as if it's their own. So if you are a property owner and you hear this and you have seen the development of this what now we discuss sooner or later, a trespass to your land, you better get on the phone and call a local attorney. Better it be James and I, and we can definitely help you and get this sorted out, because the power of express easement is, especially if you're a commercial developer, especially if you're a commercial landowner, you want to make sure that these lands that cross your line, they are in such a way that make sure that you can get to your highest and best use. So, James, so now we've discussed what easements are. We've discussed how you can determine whether you have a cause of action and you need whether you need to call an attorney or not. Again, we discussed calling sooner is better than later. Now let's discuss what happens if there is an issue that has come up. What do you mean by saying trespass?
Well, trespass, that's really important, and that's the flip side. But real quickly, let me hit on the fourth criteria for prescriptive easement. Sure. And it gets into the destruction of an easement, because an easement can be destroyed by this. And that is that the easement has to stay in repair, in good repair for that 7 years. And it's the person who has the right to the land who has that duty to repair. But trespass, love trespass, because that is another area in which you need an attorney helping you. And when we're talking about trespass, we're talking about when a person intentionally damages the property of another or maliciously interferes with the use of that person's property without the consent, or enters upon the land of another person without the consent of that person. And so you can see where we're going with trespass here. When we're talking trespass that is attempted prescriptive easement, or trespass that is a non-negotiated easement, what we're talking is what's called a continuous trespass. And so that means the trespass has been is not just a one-time event. It's basically existing for a period of time. And there's a Georgia statute that actually guides. I won't get too much into the legalese, because I didn't throw out our legal disclaimer each segment, which I'm supposed to do, but I'm not going to throw out legalese to you, because the information you hear on this show is only supposed to be information, is not taken to be legal advice. Don't rely on what you hear on this show to go ahead and start negotiating an easement, or to go ahead and file suit against someone for trespass or nuisance. You need to go ahead and contract with an attorney who can actually help you through this. And if you want some real legal advice, just go ahead and give me or Sasan a call, and we will actually help you negotiate this easement, stop the trespass, or stop the nuisance. So back to trespass. So the trespass, when it is a continuous trespass, this is where you start to get into the measure of damages. This is where you start. This is your litigation case. Your litigation case isn't that there's a prescriptive easement, though the person who's burdening your land may file a litigation case against you saying, I have a prescriptive easement, or an easement by implication. It's landlocked and I need that easement. So it can go that way. But if you're the burdened property and you don't think that there's an easement in place, and he doesn't meet a prescriptive easement or easement by implication, then you're talking trespass or nuisance.
That's right. So now we know the two sides of the coin. The first side is the easements, is when you want to use someone else's land for certain non-possessory interest. The second part is if someone is utilizing your land, your bundle of rights, without really compensating you for it. As a landowner, you can exclude them from your land, and that is going to trespass. So if there has been an unlawful entry, and this person wasn't consented and authorized to use it, now we're discussing a continued trespass, and that is the time that you have a cause of action. So we've discussed a lot in these couple of segments. We still have more to discuss. We will come back and discuss damages and how these easements are terminated. This is Attorney Namat of Namat Law Firm, where we provide legal services and mediation to Georgia land use professionals and also do EB-5 work. And you can reach us at 770-285-8008. And I'm here with Attorney James Lewis. go ahead and tell us more about your contact info, James.
Okay, you can always get in touch with me, and I love to deal with easements because I'm going to get you, the landowner, paid. I'm going to get myself paid. Number is 404, and we're going to make the person who's burdening your land pay. Trust me. 404-610-0075. You can always email me at james@jameslewislegal.com or go to my website, jameslewislegal.com.
You are listening to Lewis on the Law. This is Attorney Namat of Namat Law Firm, and I'm here with Attorney James Lewis, and we are here to talk easements, trespass, and nuisance. We've already discussed easements and trespass, James. So why don't we dig into nuisance? What are nuisance?
Nuisance it goes hand in hand with trespass, and nuisance is interference with your right to use and enjoyment of your property, and bundled in the bundle of rights that every landowner has, or every person who has a high interest in the land. I'm going to use high interest because when you get into landowner, when you really get into how land is owned, you really see that people just have a certain level of interest in land, and maybe the only real owner is the sovereign. But we won't get into that because that's a huge conversation. And so we're going to talk about a person with a high interest in land. So once you have a high interest in land, so you own that land in fee simple, then you have a right, and you don't even have to own it in fee simple. You can just have a tenancy in years, and you still have a right to the use and to the quiet use and enjoyment of that land. And nuisance is interference with that quiet use and enjoyment of that land. So it goes in this context. We're talking continuing nuisance, like continuing trespass, and the person who's burdened your land with their illegal easement, non-agreed upon easement, attempted prescriptive easement, or attempted easement by implication, they are interfering with your right to the quiet use and enjoyment of your land, and that's where nuisance comes in, and nuisance and trespass become a measure of damages. They become a cause of litigation.
That's right. And sometimes folks may have defenses to it. Let's say, if they are conforming to zoning, or if they can prove that you've come to the nuisance. However, a lot of times there's at least an injunction that you can get to stop them from nuisance, if not damages. So, James, now go ahead and tell us more about these damages. What are these damages? If you're a property owner that is listening to this, you've identified an issue, and now you need to act on that issue. How do you know if this issue is worth the trouble of pursuing it?
Well, if there's an illegal easement and you own the land, it is worth your pursuing. I'm going to tell you that right now, because there is going to be a measure of damages. You're going to have a right to a certain dollar amount. And before that, I want to tell you guys that you can actually listen to Lewis on the Law nationally on Spotify, iTunes, Google Play, and those are I only listen to like the big ones, but I know there's a zillion others that you can actually access to. Every major streaming platform, you can go ahead and catch Lewis on the Law. And okay, back to the measure of damages. So the standard measure of damages is what everyone thinks is maybe the land value, how much that land would be valued if you sold it, or how much that land would be valued if it was rented. And that is the common way to think about that. And you can find that information. There's all kinds of ways in which you can determine the square footage of the land, the cost of that land if someone had bought it. Say someone wants an easement in perpetuity, which means basically forever, then you basically sold them a piece of your land. You haven't, because if something happens and the easement is terminated or destroyed, that interest in the land reverts back to the person who has the underlying interest rights, which is the property owner or the person who has that right. So it reverts back. So you haven't really sold it, but it might as well be a sale. So that's one way to look at it. Another way to look at it is if it's an easement in gross for a certain amount of years or ends with the termination of the landowner, then you can look at it as a rental number. And there are different ways in which you can achieve that. The USDA has numbers for rental of land, for sale of land. There are also, you can get it appraised, and that's probably the most common way that that's done. But what I want to talk about is a different way to approach it, and it's one of the tactics that Sasan and I will use if we're handling this easement issue for you, and that is to not only throw those elements into it, but look at the cost of litigation, look at how much that has devalued your property, and what it's called diminution of value. And that's basically how much you're losing value because you've got these monstrous, big, gray, ugly boxes on your property. And diminution of value in Georgia, it's actually a very common standard of damages when you're talking landlord-tenant issues. That's right. That's where you really see diminution of value come into play. Is usually a tenant has paid a landlord his rent, but his apartment is constantly leaking. It's got rats, mold, cockroaches, or whatever. So the apartment is not worth what he's paying each and every single month. And so the measure of his damages is diminution of value. That same concept can be applied to real property damages. And it in Georgia, I have not seen, and not to say that there isn't, I have not seen this tested in the courts.
And, diminution value is an interesting concept because it says, but for the breach, you would have got the 100% of the value of the bargain. Now you're getting a certain percentage of it, much less of the benefit. So now that is the damages that you've incurred. And I believe, again, if you're a commercial developer, especially commercial landowner, you really want to take advantage of how that diminution is, because sometimes these sort of easements, these trespasses to your land can really mess up your prospect of highest and best use. So it is something to be of the knowledge of. So let's discuss other sorts of damages. Let's say intentional infliction of emotional distress and those sorts of other causes of actions that are more in tort, but they also come into these sort of cases. So, James, tell us more as to some of these other damages, as well as how easements are terminated.
Okay, so intentional infliction of emotional distress is a tough one, and you can use that, and I know it can become a factor in the negotiation. It can be tough to prove in court because there has to be some
tough burden to prove.
Yeah, it's a tough burden to prove, but it can always be used as a negotiating ploy, especially in my case where you've come onto the property and now you own the property and these people who've dug up your property are now threatening to throw you in jail. Then that is a threat, and you're emotionally distressed, and it doesn't look good on them that they've threatened to accuse the primary property owner of they've accused him of something that he hasn't done, and they've threatened him with incarceration. So there's always that element to help in negotiations, but you definitely want that supported with other factors.
That's right. And I'm sure jurors in the state of Georgia wouldn't like to see a homeowner being threatened to go to jail simply because they dare to go outside and ask the utility company, what are you doing on my land? So it's one of those things. So tell us more about termination of easements.
Okay, so there are several ways easements can be terminated. You can actually have, and first maybe I should talk about, because it's the final factor in a prescriptive easement, but it's if the person does not maintain that easement. They've let it grow long. The weeds have taken over it. It's become an eyesore on their property. If they haven't taken care of that easement, then you can argue abandonment, and that's one of the ways you terminate an easement. You can also actually have an express period, and then you see that in easement and gross, or sometimes an easement and appurtenant. You can have an express period in which that easement exists, and then they have to renegotiate that, or they pay you a rental fee, or however else. There's several different ways this can be structured. And of course, you always want to contact us if you need to restructure that. And merger of title. This is important because this is something that a lot of people will overlook. Okay, say and to explain this, I'm going to use a little bit of a demonstration. Say you have two properties, and one property has an easement across it that is one property is servient, and it has an easement that goes to the dominant property. Say one person buys both properties. Once one person owns both properties, the title to the properties have merged. And so if the easement is not put in place, if the easement is not expressed once that person sells the properties, then you're back into that easement has been destroyed. And a lot of people won't realize that. And but you can have some litigation over that.
Same owners, so why to have an easement to begin with? So that's grantor has become the same, and merger has happened. So in this show, if you've been listening and you've been patient with us so far, you've learned what easements are, how you can identify them, when you know your rights are being breached, when you know you have causes of actions, or the sort of measure of damages. You know how they're terminated, whether it was the release, expiration, abandonment, so on. And you know a lot more about nuisance, trespass, and you know when you got to call an attorney to help you with this. Again, thanks for giving us your time. We're getting closer to the end of the show. This is Attorney Namat of Namat Law Firm. My number is 770-285-8008. And at Namat Law Firm, we help land use professionals in the state of Georgia with land use help, legal and mediation services, and we also help foreign investors with investment immigration job-based EB-5 program. Thanks for having me on your show, James.
Oh, love having you on. You're listening to Lewis on the Law. My name is James Lewis. I would like to thank the guys that make the magic happen. The wizard of video. I'm not going to use something that doesn't rhyme. Anthony Cook over there making the magic happen. The thunderer of sound, Sam Davis, bringing the lightning with his lightning quick fingers. I don't know if that sounds good. Anyways, I love you guys. See you next week.